So in this video, we're going to start thinking about the duty of care. That's one of the duties that attaches to a fiduciary in the corporate context. Before we thought about the voting system as a constraint on management discretion, now what we're going to do is think about the lawsuit. The voting system, of course, is our primary legal machinery for regulating, if you want to think about it that way, ordinary business decisions. That is, the voting system is the mechanism for what we can think of as normal or ordinary governance. Of course, the voting system isn't regulation or regulatory in a conventional sense. It is something that shareholders can use to protect themselves by giving them the power to appoint or to dismiss members of the board of directors. As we discussed, they have to surmount the collective action problem in order to exercise those rights or to exercise them effectively. But US corporate law provides a second layer of protection that's, in a sense, more direct. That's constraining directors, officers, and as we'll see, controlling stockholders with fiduciary duties. This, in the corporate context, is the first of those we're going to look at. In the case of an ordinary business decision, the relevant fiduciary duty at play is the duty of care. This is a true governance device, albeit, as we'll see, not a very strong one. So we can think of the duty of care as a judicial backup to the voting system. Shareholders are expected to make their wishes known and put their goals into practice through appointing and removing directors. But courts might step in after the fact, ex post, if the behavior of the directors is sufficiently egregious, even if there's no conflict of interest. We'll talk a lot about conflicts of interest separately. What we're looking for, as we'll see, is a standard of sort of egregiousness. How bad is the decision? It has to be very bad. So bad, as we'll see, that it survives the defenses of the business judgment rule. This after the fact judicial review through fiduciary duties is one of the most unique characteristics of US corporate law. This is your first exposure to it. How we came to have this much reliance on fiduciary standards and the court system to administer them goes back to the English chancellor and the chancery courts of the late Middle Ages and the complicated feudal tenure system. This first duty of care case, the Sutton case from 1742. If you're interested in that, go crazy. That's the case, as I'm sure you'll recall, where early directors of a charitable corporation failed to catch the thieving managers before all was lost. But what we're going to do here is think about our basic framework for analyzing the duty of care, not the history of it. So let's start with our basic duty of care. What is it? Well, here we have an excerpt from the American Law Institute's Principles of Corporate Governance and from the Model Business Corporation Act, the revised version. Note, we're not taking something here from the Delaware Corporate Code. That's because the duty of care there is not codified. The point of looking at the ALI principles here is that this is, in a sense, an articulation of the duty of care that captures the essence of Delaware. But as we'll see when we start to look at the cases, Delaware develops the duty of care through the common law process. It's not statutory. So the ALI approach says a director or officer has a duty to the corporation to perform the D or O's functions, 1, in good faith, 2, in a manner that he or she reasonably believes to be in the best interests of the corporation, and 3, with the care that an ordinarily prudent person would reasonably be expected to exercise in a like position and under similar circumstances. So our most important prong for these purposes is that third one, the level of care we'd expect from an ordinarily prudent person. That at first glance might sound like we're going to use something like a negligence standard. Did you take, what the amount of care you should have taken? See also the RMBCA's approach is similar. The amount of care that a person in like position would reasonably believe appropriate. That's what a director has to do. As I said, the basic idea in Delaware is the same about the articulation of the standard. So here's our standard, but we have a very special rule for evaluating whether a director has lived up to this standard. And that rule is known as the business judgment rule. It's impossible to think about the duty of care without thinking at the same time of the business judgment rule. The duty of care says what it says, the standard is what it is, but when we evaluate whether someone has lived up to the duty of care, we use the business judgment rule. Again, Delaware hasn't codified this, but the ALI's articulation of it is basically the same. The ALI says, a director or officer who makes a business judgment in good faith fulfills the duty under this section. If you make a business judgment in good faith, you've satisfied the duty of care. We don't actually care how much care you've taken. You satisfy it, so long as you're not interested in the subject matter. You don't have a conflict of interest. 2, you're informed to the extent you reasonably believe is appropriate. And 3, you believe your business judgment is in the best interests of the corporation. You subjectively are trying to do the right thing. So long as you don't have a conflict of interest and you're as informed as you believe is appropriate, and you're making your decision for the right reason, you satisfy the duty of care. The standard, the articulation of the standard doesn't, in fact, make a big difference. The RMBCA has a more elaborate statutory setup, but we'll see the result is the same. Here's the RMBCA standard. I'm not going to go through all of these. Again, the point is to see, we'll go through just a couple of them. But the basic idea is we don't actually care how much care you took when we're evaluating whether you comply with the duty of care. The business judgment rule, in a sense, says if you're making a business judgment and don't have a conflict of interest and put yourself in a position to be informed on the topic, we won't hold you liable. Right? So here at the RMBCA, a director won't be liable to the corporation or stockholders for any decision as a director unless the party who's trying to hold the director liable shows that the conduct wasn't in good faith. We saw that before. The decision is one where the director didn't think it was in the best interest of the corporation or wasn't informed. Again, we've seen this. Or the director had some conflict of interest of a particular kind. Here in subsection 3, you there's a family relationship or a financial tie that is clouding your judgment. The latter ones, you're getting something different in Romanet 5, or you're not devoting enough attention to the problem in Romanet 4. Those are special cases that we're not going to focus too much on. The basic idea, again, is the same. If you make a business decision and don't have a conflict, the duty of care is generally going to be satisfied without us ever thinking about how much care you took. We'll obviously think a lot more about how to make sense of this when we examine the excerpt from the Gagliardi case.